Lords, you have three documents on your desk. They were promised yesterday. There are two, first of all, the E3G document that I told you about, gas for development, that was handed up to the court below. E3G is a highly regarded think tank used by the government and the Environmental Audit Committee. Then you have a report from Mozambique about Mozambique's climate position to deal with the evidence in relation to Mozambique's vulnerability. Again, that was before the court below. And finally, you have a note drawn up by my junior, which deals with revenues to Mozambique. It is drawn from Mozambique government information, all of which is within the files. And I hope it will help to shorten my submissions in relation to the true revenue position.
Well, it will if I get it electronically.
You will get it electronically, my lord. And what it shows essentially in paragraph 6 is that Mozambique will not receive significant revenues until 2030. Now, my lords, I want to start with paragraph 1 of the respondents' skeleton argument. It's in core bundle at tab 8, page 66. And this is just to deal with what the respondents found in relation to Paris Agreement compatibility. So paragraph 1 of their skeleton, in 2020, the UK government decided to provide export finance in relation to an LNG project in Mozambique. In taking that decision, as part of its due diligence, UKEF decided to have regard to the extent to which that decision would be consistent with the UK's international law obligations under the Paris Agreement. UKEF judged that its decision was consistent with those obligations. Now, in the respondents' evidence and pleadings, UKEF determined that the finance was consistent with the UK's obligations under the Paris Agreement, including 1, with a low emissions pathway, and 2, more widely as regards its obligations to developing countries. The decision was that the UK was acting compatibly with the Paris Agreement in financing the project, and the ministers and the Prime Minister proceeded on that basis. This is the only position that the respondents have ever taken in these proceedings. And, my lords, the court here in appeal cannot proceed on some other basis apart from the pleadings. And I'm going to take, my lords, to a few of the references. First of all, the detailed grounds of defence. That is in Core Bundle 1, tab 15, page 364. And because, my lords, I'm going to have to proceed at quite a pace today, I would just ask your lordships to sideline the entirety of paragraph 75, which indeed Lord Justice Stuart-Smith sets out in his judgment, and read that at a later point. Can I take you, however, to paragraph 76? On the facts, UKEF concluded that its decision was broadly consistent with the Paris Agreement, and in particular was consistent with a pathway towards low greenhouse gas emissions and climate resilient development. The claimant contests this conclusion. And then if we go to 90 to 91, again, if you could sideline that to read that. And that, it's 80, paragraphs 80 to 91. That shows why they say their assessment was in line with the low emissions pathway and defensible. And then to paragraph 102, the claimant appears to contend that it was an error of law to conclude that the provision of export finance in relation to the project was consistent with a pathway towards low greenhouse gas emissions and climate resilient development. So yes, we contested it. And then 102.2, Further, and in any event, UKEF expressly considered whether the decision was consistent with a pathway towards low greenhouse gas emissions and concluded that it was. And then, if we go to 108, the claimant's contention that providing support to the project undermines the UK's commitments under the Paris Agreement is another argument on the merits. UKEF took the view that its support was broadly consistent with the Paris Agreement, and in particular, that it would align with the UK's government to support developing countries to respond to the challenges and opportunities of climate change as part of the UK's own Paris Agreement commitments. And then 108.3. The claimant is plainly wrong to suggest that emissions were only looked at from the perspective of Mozambique's NDC. UKEF's climate change report looked at matters at the host country level and also at the international level. And then 111, last line, last sentence. The IMF judged that the project would help reduce GHG emissions. US Exim and African Development Bank judged that the project would be likely to result in a net reduction of GHG emissions. Not in fact correct, but nevertheless, as a matter of fact not correct, but nevertheless relied on to support the idea of a low emissions pathway being in alignment. And then if we go to 117.3, as has been explained above, in its climate change report, UKEF did consider the consistency of the project with a pathway towards low GHG emissions in both Mozambique and globally, and concluded that providing support in connection with the project would be consistent with such a pathway and climate resilient development, and would support Mozambique to respond to climate change. And then 117.4, last sentence. UKEF did not accept the proposition that the Paris Agreement requires there to be no new production of gas in the future. UKEF agreed with the IEA analysis, which takes a different view of the position that's in relation to the pathway. And I'm just going to give you the reference to the summary grounds of defence, same position taken. Paragraph 39.3, 44, 61.2, 67, 67.3, 76.3, and the last line of 76.4. And, my lords, there are many other references, only one more for you now. The statement of Mr. Taylor at Supplementary Bundle, tab 60, page 476, paragraph 85, and paragraphs 90 to 91. If the respondents had been able to say that ministers had not been advised that the finance was compatible with the UK's obligations under the Paris Agreement, and specifically the low emissions pathway, as well as climate resilient development, then they could and would have said it. These pleadings, my lords, are subject to a statement of truth by the decision maker. They must be taken by the court to be true. And indeed, Mr. Taylor, at paragraph 134 of the statement, states that he has seen them, and he states that he believes them to be true. The finding of such compatibility prior to the decision is in line with the fact that UKEF assesses against the international agreements the UK has signed up to, and does not usually fund if in breach of international agreements. And you find that all set out in paragraph 8 of our skeleton, which I'm not going to go to now. But for the UKEF policy, my lords, if we can go to Supplementary Bundle, tab 14, page 109, paragraph 3.
This document is the
UKEF's policy document,
UK's policy document,
which was applicable at the time.
Can we just have the reference again?
Sorry, it's Supplementary Bundle, tab 14, page 109. Paragraph 3. We will comply with all international agreements which apply to the operation of ECAs. These agreements include the OECD Council recommendation on common approaches for officially supported export credits, which informs the way in which ECAs should address ESHR for projects existing. And then skip the next bullet and go to the last one in there. It says, we will not operate beyond international agreements which apply to ECAs. And then skip the next one and move to the OECD. The OECD Common Approaches recognises that the primary role of ECAs is to promote trade in a competitive environment, in contrast to development banks, which focus primarily on development assistance, and that ECAs have a responsibility to consider the positive and negative ESHR risks and impacts of projects, in particular those in sensitive sectors or located in or near sensitive areas, and the ESHR risks associated with existing operations in deciding whether to offer support. And then moving down 2 paragraphs, in line with the OECD Common Approaches, we identify ESHR risks and carry out due diligence to be satisfied that the projects should comply with applicable local and relevant international laws and align with international ESHR standards before support is provided. And in the next tab, which I'm not going to take you to now, that statement is made to Parliament. Now, I'm going to take you to the OECD Common Approaches, and that is in Authorities Bundle 4. Tab 58, page 3314. Now, in addition to the express reference that I just took you to in relation to international agreements applicable to ECAs, which we say would include the Paris Agreement because the ECA is plainly an emanation of the state. In addition, the OECD approaches specifically refers to the UNFCCC, and the Paris Agreement is, of course, a treaty adopted under the UNFCCC. And you find that on page 3314. About 2/3 down the page, my lords will see, recognising the responsibility of adherents to implement the commitments undertaken by the parties to the UNFCCC. And although the respondents say in their pleadings that the Paris Agreement is not an international agreement that applies to ECAs, which we dispute, they do accept that the Common Approaches does apply, and the Common Approaches brings in the Paris Agreement in any event. If you then go to page 335 here, you'll see in the second bullet under definitions, due diligence is the process through which adherents identify, consider and address the potential environmental and social impacts and risks relating to applications for officially supported export credits as an integral part of their decision-making and risk management systems. And then 3316 under objectives. The objectives of this recommendation are to promote coherence between adherents' policies regarding officially supported export credits, their international, environmental, climate change, social and human rights policies, and their commitments under international agreements and conventions, thereby contributing to sustainable development. And then under Roman 3, promote good practice and consistent review and assessment processes for projects and existing operations benefiting from officially supported export credits with a view to achieving a high level of environmental and social performance as measured against the relevant international standards. So there can be no denying that the Paris Agreement, whether directly, which we say is the case, or indirectly through the OECD Common Approaches applies to UKEF. It is unsurprising, therefore, that its policy is to comply with international agreements and the OECD Common Approaches and only to grant finance in those circumstances. For that reason, my lords, that the defendants did assess alignment with the low emissions pathway, as well as their obligations to support developing countries when deciding whether to grant finance, and concluded that the United Kingdom would not be in breach of the Paris Agreement if it granted this finance. And it is for you, my lords, to decide whether that was correct in law or not. Now, my lords, the next stage in my submissions is to return to where we were yesterday and to deal with the Paris Agreement, the UNFCCC, what it actually says, does, and requires. And I'm going to start with a little history of the UNFCCC through to the Paris Agreement before taking you to the provisions. The UNFCCC was adopted 4 years after the IPCC. It's a science-based agreement, and that's central to the entire analysis of its terms. It provides in Article 2 for the stabilisation of greenhouse gas concentrations in the atmosphere, but it didn't specify a particular level or temperature. It didn't contain a long-term temperature goal, but it was widely recognised that such a temperature goal was needed. But of course, because as I explained yesterday, the temperature goal necessarily entails a specific budget for carbon in the atmosphere. And there is obviously going to be contention between parties, therefore, as to what that temperature goal should be. Agreement on the temperature goal first took place in 2010 in the Cancun agreements, and there the parties agreed to reduce emissions to prevent global temperature increase of more than 2 degrees above pre-industrial levels. Now, as at 2015, the intended nationally determined contributions notified at that date would not have enabled even that limit to have been met, let alone 1.5 degrees. It had been recognised long before then that it was necessary to take swifter action because of that failure. And the Paris Agreement represented a response to that urgency. It was a recognition, as I said in opening yesterday, of the need for all countries to act and for the financial system to be reorientated to support them as a matter of urgency. It recognised the need also for assistance by developed countries to developing countries in terms of finance, technology, and other support. And I'll explain this by reference to the provisions when we get there. So when the COP adopted Paris in 2015, it also asked the IPCC to examine the position that would occur if temperatures rose by 1.5 degrees as compared with 2 degrees. And I showed you SR 1.5 yesterday and the significant implications of not meeting 1.5 degrees. I will now deal with the meaning and effect of the relevant parts of the Paris Agreement. In our submission, my lords, Mrs. Justice Thornton correctly interpreted the meaning and effect of the relevant provisions, and you find that in paragraphs 261 to 270 of her judgment, and we rely on her analysis and respectfully request the court to uphold it. Interestingly, as she noted, this is also the analysis that the respondents themselves purported to apply when considering the project, and I'll take you to that when we consider ground one. By contrast, Lord Justice Stuart-Smith analysis renders both the UNFCCC and the Paris Agreement entirely nugatory. Similarly, the respondent's interpretation before this court, which seeks to uphold that approach, has that effect, and contradicts the government position regarding alignment of finance flows with the Paris Agreement, now actually in the UK's NDC. I'm going to start with the UNFCC, which you find in Authority Bundle 1, tab 3. As I said, it followed years of science and dating back to the Stockholm Declaration in 1972, when the UN started requesting that scientific analysis. It was in force from the 21st of March 1994, and if we start with the first recital, recital 2, on page 12 of the bundle, the parties to this convention concerned that human activities have been substantially increasing the atmospheric concentration of greenhouse gases, that these increases enhance the natural greenhouse effect, and that this will, on average, in an additional warming of the Earth's surface and atmosphere, and may adversely affect natural ecosystems and humankind. And then recital 7, you see, refers to Stockholm, recital 11, to various resolutions that precede this document, and then recital 16, which is on page 13. It's rather irritating they don't number the recitals. I always number them on the left. So it's the middle of page 13 of the bundle. Recognizing that steps required to understand and address climate change will be environmentally, socially, and economically most effective if they are based on relevant scientific, technical, and economic considerations and continually re-evaluated in the light of new findings. That's the continual reports of the IPCC. And then 17, recognizing that various actions to address climate change can be justified economically in their own right and can also help in solving other environmental problems. 19 and 20, just at the bottom, recognizing further that low-lying and other small island countries with low-lying coastal, arid and semi-arid areas or areas liable to flood, drought and desertification, and developing countries with fragile mountainous ecosystems are particularly vulnerable to the adverse effects of climate change. That's Mozambique, is one example of such a country. And then on the next page, 21 to 22, affirming that responses to climate change should be coordinated with social and economic development in an integrated manner, so it all goes together, with a view to avoiding adverse impacts on the latter, taking into full account the legitimate priority needs of developing countries for the achievement of sustained economic growth and the eradication of poverty. And then 22, my lords, can also read, again refers to the problems for developing countries. And then if we go to Article 2, my lords find the overall objective, which is the key provision we need to look at. The ultimate objective of this convention and any related legal instruments that the Conference of Parties may adopt, that includes then the Paris Agreement, is to achieve, in accordance with the relevant provisions of the Convention, stabilization of greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference in the climate system. That is a scientific question. Such a level should be adhered within a timeframe sufficient to allow ecosystems to adapt naturally to climate change, to ensure that food production is not threatened, and to enable economic development to proceed in a sustainable manner. all scientific questions. And then Article 3, just in their actions to achieve the objective of the Convention and to implement its provisions, the parties shall be guided inter alia by the following. And then if you just go to 3, the parties should take precautionary measures to anticipate, prevent, or minimize the causes of climate change and mitigate its adverse effects. Now, we are way past the precautionary stage because the science has now reached a stage of 100% certainty. Nonetheless, it's important to recall that the concept of precautionary approach. Now, at that time, the time of this, there was a bifurcation between the responsibilities and obligations of developed countries and developing countries, and you find that in Article 3. I'm not going to take you through the technical nature of that bifurcation now. And then
sorry, the date was 92, is that
92, right? And it came into force in 1994, 21st of March 1994. And then just to point out Article 7, there you find the Conference of the Parties, which is COP. And then you'll see in Article 24 that this treaty prohibited any reservations. So turning then to the Paris Agreement, you find in the next tab, page 36 of the bundle, the Paris Agreement was signed on the 22nd of April 2016. It was laid before the United Kingdom Parliament, and there was no objection to its ratification, and it was subsequently ratified on the 18th of November 2016 and came into force in 18 December 2016 for the purposes of the United Kingdom. Now, if we can start, in fact, with the decision to adopt Paris, and that actually is at page 68 in the bundle, tab 5. And I take you to this because, of course, in applying Article 31 and 32 of the Vienna Convention, you are entitled to look at such decisions that precede the adoption of the treaty itself. So this assists you in understanding what it was for and why it was happening. So in 2011 at Durban, the Conference of Parties, the COP, adopted this decision, recognizing, this is page 69, recognizing that climate change represents an urgent and potentially irreversible threat to human societies and the planet, and thus requires to be urgently addressed by all, I emphasize all parties, and acknowledging that the global nature of climate change calls for the widest possible cooperation of all parties and their participation in an effective and appropriate international response with a view to, and I emphasize, accelerating the reduction of global greenhouse gas emissions. Noting with grave concern the significant gap between the aggregate effect of parties' mitigation pledges. These were in Cancun in 2010. I mentioned Cancun as the temperature limit. This is when we got the pledges. In terms of global annual emissions of greenhouse gases by 2020, and aggregate emission pathways consistent with having a likely chance of holding the increase in global average temperatures to below 2 degrees or 1.5 degrees above pre-industrial levels. And then below, under number 2, also decides to launch a process to develop a protocol. That's what became the Paris Agreement. Here they're proposing a protocol to the UNFCCC, or another legal instrument, or an agreed outcome with legal force under the Convention applicable to all parties through a subsidiary body under the Convention, hereby established and to be known as the Ad Hoc Working Group on the Durban Platform for Enhanced Action. So they decided to set up a working group to produce a legal instrument or protocol with legal force applicable to all parties. And then under 4, decides that the Ad Hoc Working Group on the Durban Platform for Enhanced Action shall complete its work as early as possible, but no later than 2015, in order to adopt this protocol, another legal instrument, or an agreed outcome with legal force at the 21st session of the COF, and for it to come into effect and be implemented from 2020. And then further about its work in 5 and then 6, further decides that the process shall raise the level of ambition and shall be informed inter alia by the 5th assessment report, that's the IPCC, so again, science central to this. The outcomes of the 2013 to 2015 review, that was a review between experts, and the work of the subsidiary bodies, all convention bodies. And then 7 decides to launch a work plan on enhancing mitigation ambition to identify and explore options for a range of actions that can close the ambition gap with a view to ensuring the highest possible mitigation effort for all parties. And a core option that they came up with and was decided on was the reorientation of finance. If we then go to the Paris Agreement in the previous tab, we can start with recital 5, recognizing that climate change represents an urgent and potentially irreversible threat to human societies and the planet, and thus requires the widest possible cooperation and their participation in an effective and appropriate international response with a view to accelerating reduction of GHG gases. And the following, also recognizing that deep reductions in global emissions will be required in order to achieve the ultimate objective of the Convention, and emphasizing the need for urgency. And then recital 9, which starts with emphasizing with serious concern the urgent need to address the significant gap. By this time, we had had further pledges, voluntary pledges, that had happened in the Copenhagen-Cancun Accord, so previously, emphasizing the serious concern, the urgent need to address the significant gap between the aggregate effect of the parties' mitigation pledges in terms of global annual emissions of GHG gases by 2020 and aggregate emission pathways consistent with holding the increase in the global average temperatures to well below 2 degrees above pre-industrial levels, and pursuing efforts to limit the temperature increase to 1.5 degrees. Now, if my lords could cross over the page, we're going to come back to that. At this point, I want to actually take you to that gap, which is fully explained in the decision from paragraphs 12 onwards. That's page 38 of the bundle, just the next page. So you see there, this is the decision adopting Paris. The gap is explained, and this gap is the analysis that has been done by the IPCC in its 5th assessment report, which just preceded this decision. So paragraph 12 welcomes the intended nationally determined contributions that have been communicated by the parties in accordance with 1 CP 19 paragraph 2p. That was the Warsaw platform. And then at 17, no, 16 and 17, takes the synthesis report on the aggregate effect of the intended nationally determined contributions communicated by the parties on 1 October 2015, contained in that document, and then following, notes with concern that the estimated aggregate greenhouse gas emission levels in 2025 and 2030 resulting from the NDC's contribution do not fall within the least cost 2 degree scenarios, but rather lead to a projected level of 55 gigatons in 2030, and also notes that much greater emission reduction efforts will be required than those associated with the INDCs in order to hold the increase to 2 degrees above pre-industrial levels by reducing emissions to 40 gigatons or to 1.5 degrees above pre-industrial levels by reducing them, as referred to in paragraph 21 below. And if you then cross-refer to paragraph 21 just below, you'll see that the COP then invites the IPCC to produce a report about 1.5 degrees, so bringing it into the Paris Agreement. And that report becomes SR 1.5, which is produced in 2018. If we then go back to the recitals, you'll see just from 10, emphasizing enhanced ambition can lay a solid foundation pre-2020, so urging action now as a solid foundation for post-2020 ambition, because it was not expected that this treaty would successfully come into force before 2020. In fact, that is what happened. 11, stressing the urgency again and accelerating the implementation. And then 12, again recognizing the urgent need to enhance the provision of finance technology and capacity building in order to enable enhanced pre-20 action, so that's under the UNFCCC. And then 13, enduring benefits of ambitious and early action. And then 14, acknowledging the need to promote universal access to sustainable energy in developing countries, in particular Africa, through the enhanced deployment of renewable energy. Agreeing to uphold and promote regional and international cooperation in order to mobilize stronger and more ambitious climate action by all parties and non-party shareholders, including civil society, the private sector, financial institutions, cities and other subnational authorities, local communities and international indigenous peoples. This is again all about reorientating the entire economies of the world towards a renewable net zero approach. Then paragraph 1, we have the decision to adopt the agreement. And it's clear that it is a treaty, and there is no dispute as to that. And then if we go over to 3, my lords, on the next page, page 39, you'll see a heading, decisions to give effect to the agreement. And I'm not going to read all this now, but these efforts explained on pages 39 through to 43 are all mitigation efforts. Mitigation meaning reduction of emissions. And effectively, they include NDCs, policies, mechanisms, market and non-market mechanisms. So market mechanisms might be, for example, carbon trading, finance, all finance, you find that at paragraph 44, and then climate finance specifically, paragraph 47. And you see at paragraph 36, low emission development strategies, and paragraphs 25 and 27, NDCs. Paragraph 36 specifically refers to developing countries. And then paragraph 44, all financial institutions. Invites all relevant UN agencies, international, regional, national financial institutions to provide information to parties through the Secretariat on how their development assistance and climate finance programs incorporate climate proofing and climate resilient measures. And then 53, finance. Decides that in implementation of the agreement, financial resources providing to developed countries should enhance the implementation of their policies, strategies, regulations and action plans and their climate change actions with respect to both mitigation and adaptation to contribute to the achievement of the purposes of the agreement as defined in Article 2. And then 54 is actually specifically climate finance. And then paragraph 64 refers to the Standing Committee on Finance. That's a UNFCCC body, which also stands as a body to serve the Paris Agreement. And you'll perhaps recall the quote from the Standing Committee on Finance in Mrs. Justice Thornton's judgment, or it may also have been set out by Lord Justice Stuart-Smith, where he says that it says that all finance must be realigned. It can be that finance has a neutral effect on climate, but it must not have a detrimental effect. And then the Paris Agreement itself, which eventually you get to on page 56 of the bundle. And if my lords could read what are recitals 4 to 10, starting from recognising the need for an effective progressive response. Just down to taking into account the imperatives of just transition. And I just emphasize the one that starts emphasizing the intrinsic relationship that climate actions, responses and impacts have with equitable access to sustainable development and the eradication of poverty. And then at 2.1a, you'll now be familiar with this, you find the central objective. The agreement in enhancing the implementation of the Convention, that's the UNFCCC, holding its objective, including its objective, that's the objective I took you to in Article 2, aims to strengthen the global response to the threat of climate change.
I'm not following. Where are you reading?
Sorry, Article 2. It's on page
Article
57.
2 itself. Sorry. Yeah, thank you.
So here it refers to enhancing the UNFCC, and specifically the objective, which is Article 2 of the UNFCC, aims to strengthen the global response to the threat in the context of sustainable development. So this is all in the context of sustainable development and efforts to eradicate poverty, including by holding the increase in the global average temperatures to well below 2 degrees above pre-industrial levels and to pursue efforts to limit the temperature increase to 1.5 above pre-industrial levels, recognizing this would significantly reduce the risks and impacts of climate change. And then B is about adaptation, and C, making finance flows consistent with a pathway towards low greenhouse gas emissions and climate resilient development. And you'll recall that the pathways are set out in SR at 1.5, but also in AR5 and all the previous assessment reports by the IPCC. And then if we go to Article 4.1, you'll see that this sets out the temperature goal. In order to achieve the long-term temperature goal set out in Article 2, parties aim to reach global peaking of greenhouse gas emissions as soon as possible, recognizing that peaking will take longer for developing country parties, and to undertake rapid reductions thereafter in accordance with the best available science, so as to achieve the balance between anthropogenic emissions by sources and removals by sinks of greenhouse gases in the second half of the century, that is net zero by 2050, on the basis of equity, and in the context of sustainable development and efforts to eradicate poverty. Now, while Article 4.1 doesn't specifically set out the pathway, you effectively find that in paragraph 17 of the decision that I took you to and showed you. So that is the pathway that talks about the emission needs. So it ties it back to the science. That is the need to reduce emissions by a particular level of gigatons, so that per annum only a certain level of gigatons were reached.
Can you just remind me where that is?
That's on page 38.
Thank you. Can we just go back to that for a second?
So this is it's paragraph 16 and 17 that ties back what is required to meet the 2-degree pathway. And these pathways are provided effectively in these documents.
You say that Article 2 should be construed in the light of the recitals?
Yes, absolutely. The recitals are always assist in construing object and purpose and meaning.
So you say pathway means
what? All of this is tied to the science, and the decisions themselves adopting these agreements refer specifically to the IPCC reports, and then it's actually a report referred to in paragraph 16, which is actually a synthesis report drawn up by the Conference of Parties that brings together that science, and it is on the basis of that science that the various pathways exist. I think perhaps you'll recall yesterday, there is not a single pathway. But the crucial point is the percentage by which emissions need to be reduced. And you'll see that in paragraph 16, specifically a reduction of 40 gigatons of emissions per annum by 2030 needs to have been reached globally. That effectively would be a line on the pathway. And I showed you that yesterday on the graphs.
you're saying that pathway in 2.1c must mean pathway set out in paragraph 16 of the document you showed us.
And 17. The low emissions pathways that are referred to both in 2.1c, a pathway to low greenhouse gas emissions, and in 4.1 to net zero in the second half of the century, depend on the IPCC science that has been brought together by the parties in a document on which this decision was based, which is FCCC CP 2015-7. We haven't provided it to you, but that is essentially what has happened.
Paragraph 17 doesn't refer to a pathway, does it?
No.
It refers to a destination, one might say.
Well, it's a pathway because the destination of 2030 needs to lead to the net zero eventually. So it's a step on the pathway.
Well, it's as if one is joining 2 points in time, isn't it?
Exactly.
Paragraph 17 is noting with concern, and it goes on to explain what is believed to be the destination to which the party should be striving, I think. Doesn't use that
That's
language.
right.
Is that right?
That's
so
right.
The pathway is really the you say, is inferentially the connection between point 1 and point 2 in time. Point 2 in time being 2030.
Point 3 is 2050, which is set out in 4.1.
Yes, that's right.
So point 3 is 0, and at 2030 we have to be at 40 gigatons per annum globally in order to get to 0 at 2050.
That's what I'm saying.
Yes. So that creates a pathway.
Yeah, the pathway is to be inferred from those points on the journey.
Exactly.
Can I ask you how we interpret the provisions of Article 2.2? This agreement will be implemented to reflect equity and the principle of common but differentiated responsibilities and respective capabilities in the light of different national circumstances. And the last words of Article 4 saying that they're achieving these goals on the basis of equity and in the context of sustainable development and efforts to eradicate poverty. Now, plainly, Mozambique is in the bottom category of poor nations and would have a very good case for saying, on the basis of equity, we must be allowed more emissions and you must be allowed, you rich nations must be allowed less emissions. How are we to know, in any kind of legal sense, how is anybody to know that there is a clear answer to whether emissions from such a country, bearing in mind the wording I've drawn attention to, is in breach of making the finance flows consistent with any of the pathways towards net zero, because there could be an infinite combination of emissions and reductions of emissions as between developed and undeveloped nations, some of which would lead to net zero and many of which would not. But how do you get what you want out of this document when that uncertainty exists? And unless you say there can be no new fossil fuel project, and I don't think you do say that.
So, just to address that in stages. First, my lords, there is a distinction between global emissions and national emissions. And in relation to this project, we are essentially concerned with global emissions. If Mozambique is to use this gas, as we understand it from the documents, it will only use 5% of it. 95% of this gas is for sale on the global market.
Yeah, but uses the money.
But the money is irrelevant for these purposes.
No, well, that's what I'm asking you.
Well, that is my...
Equity is about money, and eradicating poverty is about money.
Yes. And what the Paris Agreement provides for is the movement of money. Now, whether that actually, what one also has to recall is that the countries like Mozambique and the small island states were pushing for a lower temperature limit. So I'm going to go back. First of all, we have to start with Kyoto. There was always differentiate.
I mean, I don't want to stop you, but we've been back to Kyoto in a way. And what I'm asking now about, which, you know, forgive me, I'm you might say, a black letter lawyer. I'm looking at these words, and I know we want a purpose of construction. I know we have to look at all the background. I know we need to apply the Vienna Convention. But looking at these words, how do these words get you where you want to go when you can't say there can be no new fossil fuel project? Because this transfer of emissions from developed nations, if that's what it is, to a very undeveloped nation which is in a situation of very bad poverty, if the developed nations performed their side of the bargain and reduced their emissions much more quickly than anybody else, in theory, on the principle of equity and sustainable development and eradicating poverty, you would still be on a pathway towards low greenhouse gases. How do we know it's not that?
Well, we know that that's not, because there is no such transfer. There is a mechanism in Article 6 to provide for transfer between states of emissions.
Right.
That is not an issue here.
No.
We are not in a situation where Mozambique is, the developed countries are transferring emission entitlements to reduce it.
So, I mean, your position then is that this project is itself inconsistent with the Paris Agreement completely.
Yes. And my lord, that is the United Kingdom's position today. It is also the EU's position today, and the European Bank's position today, and the international, well, I'll take you to all these documents. So that is the internationally accepted
But that's
position.
a very strong point you've got, is that we the UK, have said that it is inconsistent with the Paris Agreement.
Yes.
But unfortunately, I no more accept your construction of the Paris Agreement than I do accept the UK government's construction of the Paris Agreement, because they seem to have had two views about it. So,
Well, my lord,
if you're right and we have to decide precisely what it means, then we have to look at the words of it and look at its purpose and look at its context.
Well, my lord, I've obviously read into the background of this agreement, and I can tell you from what I have read, what is said to be the history of this. I was actually intending to give you a big history of the whole agreement, but because of time, I haven't been able to. But this clause 2.2 represents a compromise, effectively, between the United States and China. Because prior to Paris, China did not have obligations under the UNFCCC to reduce its emissions. And the United States left Kyoto, followed by many other countries like Japan, because they were fed up with reducing their emissions when China had overtaken them in terms of emissions.
We've seen the graph.
Yeah, yes. And so as a result of that, this new agreement was negotiated, whereby all countries signed up to the emission reductions. And the reason I mentioned the 1.5 degrees in the small island states is because for certain countries, 2 degrees seems fine. But for countries like Mozambique or small island states, even 1.5 degrees is not fine. So there was also a negotiation about what would be acceptable for everybody to sign up to. So this was a compromise, effectively, between two big powers to reflect a negotiation between developed countries and developing countries and it drew on the same concepts of common but differentiated responsibilities that existed under Kyoto. So, if as I've explained, the temperature goal is directly connected, indeed in a direct linear fashion, with emissions and specific budgets, which if exceeded will mean that the goal is not met. And those low emission pathways were known at the time that the parties adopted the Paris Agreement. So they understood what they were signing up to in terms at least of global average. Perhaps I should mention that now. I think I've already mentioned it, but within the agreement, under Article 4, 5 and Article 9, and certainly in our skeleton argument, there are provisions specifically for green finance and finance between developed and developing countries. So developed countries are obliged to assist developing countries to develop renewables and energy that is sustainable. And that was also reflected in the recitals that I took you to.
Article 4.5 is support shall be provided to developing country parties.
Yes.
And the parties are those listed in the annex, is that right?
Actually, the there's no listing. The annexes only arise under Kyoto.
Yeah, so that...
so it's just, presumably there is some kind of acceptance as to what country is a developing and what is a developed country.
yes, but both 4, 5 and 9, Articles 4, 5 and 9, refer to, respectively, developing country parties and developed country parties. Is that right?
We'll check, but
Yeah.
as far as I know, there is no list as to which country belongs where.
No.
I haven't come across anything.
No, but that terminology is used consistently in the agreement, I think.
Yes, perhaps it relates back to the convention. We'll check whether there's a
Yes.
definition.
That would help us, I think.
Yes.
Thank you.
So 2.1c and 4.1 is a recognition that to achieve the temperature goals requires a transformation of the global economy, namely a redirection of finance flows from unsustainable to sustainable infrastructure and practices to meet the low emissions pathway, that is the pathway set out in 4.1 by reference to the temperature goal in 2.1a. It's a recognition that NDCs alone, as stated in the decision, will not meet the goal. And therefore the global stocktake, which is a means by which the Conference of Parties looks at what is actually happening, and you find that in 14.1 and 14.3, you'll see that the Conference of Parties, serving as the meeting of the parties to the Paris Agreement, shall periodically take stock of the implementation of this agreement to assess collective progress towards achieving the purpose of this agreement and its long-term goals, referred to as the global stocktake. It shall do so in a comprehensive and facilitative manner, considering mitigation, adaptation and means of implementation and support in the light of equity and the best available science. And then 3, the outcome of the global stocktake shall inform parties in updating and enhancing in a nationally determined manner their actions and support in accordance with the relevant provisions of this agreement, as well as in enhancing international cooperation. And there are provisions for informing the COP of what you have done as a state, and you have the United Kingdom's document whereby it informs the UN of what it has done, and it sets out all its climate finance, etc., to show the extent to which it has assisted globally in the reduction of emissions. What it does not set out there is the extent to which it has actually assisted in the increase in global emissions, which is obviously relevant. And then we turn to Article 3. As nationally determined contributions to the global response to climate change, all parties are to undertake and communicate ambitious efforts as defined in Articles 4, 7, 9, 10, 11 and 13 with a view to achieving the purpose of this agreement as set out in Article 2, including finance flows. The efforts of all parties will represent a progression over time while recognising the need to support developing countries for the effective implementation of this agreement. Again, developing parties are also bound by this agreement. It is not confined, Article 3 is not confined to national emission reductions. On the contrary, these are measures and contributions to meet the objectives in Article 2 in order to achieve the temperature goal in Article 2.1a, and so they incorporate all measures. Now, the respondents may say otherwise before this court, but the UK, in its NDC, we discovered a couple of days ago, recently updated, refers to this international effort and specifically refers to the ending of finance for fossil fuels. And you have that in Supplementary Bundle 4.
Sorry, I did have a Supplementary Bundle 4. What is that?
And actually, I've got the wrong number. Maybe it's Supplementary Bundle 3. It is the bundle that we sent up.
It's the one with the
Eric?
additional documents
Yes.
of 10th of November and 11th of November.
No, I believe it may even
It's
have
after
been
that.
the morning of the court or the day before court. It's a Blackstone bundle.
What's it called?
It's called Appellant's Further Supplementary Bundle.
Further separate.
Does it begin with the Stockholm Declaration?
Yes.
Yes. Right.
And you'll see in tab 4. Oh, I've got it.
This is the NDC.
This is the 2020, the UK's 2020 NDC, updated in September 22. And I thought I had marked, should be marked up. Yes.
There is some
Page-
sidelining in it.
Page 31, yes, sidelined. So page 31, you'll see in the second bullet, committed to ending, so this is something that United Kingdom has now done. Actually, perhaps start on the previous page. Since its NDC was first communicated in December 2020, the UK has made progress on a range of specific policies and measures that will support delivery of the NDC. For example, as of September 2022, when the UK submitted its updated NDC, the UK has, the next page, second bullet, committed to ending Her Majesty's Government's direct support for fossil fuel energy sector overseas.
Where did it do that?
It did that.
It says
did-
it has committed.
It
but
did
where
it
is
in March. I showed you yesterday the announcement by the Prime Minister in December 2021, and then the implementation of the policy from March 2021. And I took you to the policy, which is in the supplementary bundle at
I would be interested to see how that relates to the documents you were showing us yesterday, which were promulgated in the summer of 2020.
Well, on 1 July
Yeah.
2020, the CDC, now the British International Investment, ended all fossil fuels on the basis that under the 2018 World Resources Institute document, such finance was misaligned with Paris. It was only at COP that the Prime Minister announced the ending of fossil fuels from finance from UK.
But this speaks of a commitment to ending, which sounds like the future.
No, they had done it already. What they're doing is they're saying, this is what we've done since we have committed to.
It says the UK has committed.
Yes.
Yeah.
It sounds like it has committed.
Yes. It did. It committed.
What I asked was where?
I have 58 supplementary bundle. So I took you to Prime Minister's announcement in December 21.
Yes.
And then in March 22, you have... March 21, sorry. December 2020, the Prime Minister announces at COP that the UK will not fund fossil fuel developments anymore, even from UK.
Mm-hmm.
So already on the 1st of July ended by CDC. And prior to that, of course, in the Green Finance Strategy, you'll recall that all official development assistance would align with Paris. Yeah, page 442. So you have then in March 2021, the actual policy is promulgated in relation to UK financing, all UK financing for fossil fuels. And you'll see that there was an absolute prohibition on the financing of fossil fuels for the global market. And you might recall that that was in the footnote, because there are some exceptions where the United Kingdom might, for example, assist a developing country to open up a small resource for its national use, if it could be shown that that was directly connected with a clear and specific pathway to net zero as set out by the relevant country. And that's all set out in the policy document.
I'm just looking at the very helpful chronology, which we find in the core bundle, roughly at page 60. See whether we can find these dates there. December 2020, this is on page 64. Government announces new policy ending financial support for overseas fossil fuel projects, including overseas development assistance and export credits other than in limited circumstances. So that was the Prime Minister's announcement at COP26.
That's right.
Is that right?
And then at 31 March, below in italics, you see the policy is promulgated.
Aligning UK international support for the clean energy transition in force as of the 31st of March.
And where does it say that the fossil fuel financing overseas would be in breach of the Paris Agreement?
It says that to align with the Paris Agreement. So it says, it doesn't, there's no, it's the world resources in the CDC document. That was Commonwealth Development Commission finance, now British International Investment. In that document, on the 1st of July, which you find in 1st of July 2020, tab 51, in that document, there is a reference to the fact that certain financing is misaligned with Paris.
Who is CCC? CDC?
CDC is the Commonwealth Development Corporation.
And is it an organ of the British government?
Yes.
Right.
And it's now British International Investment.
This is Page 388.
Page 388.
Mr. O'Donoghue, Chief Executive Officer, saying, we will not make new investments either directly or through a fund in fossil fuel subsectors that we have classified as misaligned with the Paris Agreement.
Precisely.
In the rare cases where we would consider making a fossil fuel related investment beyond these subsectors, it would only be to support a country in its transition to a net zero carbon future.
Exactly. And then if you see footnote 1, you see the reference to the World Resources Institute document, which is a 2018 document, and you can find that referred to in their guidance, which is at page 420, footnote 2, and you'll see in the middle of the paragraph under 1.2 that
Sorry, what page?
page 420, you'll see that at this time CDC is determining whether certain financing is aligned or misaligned by reference to World Resources Institute classification, and you'll see footnote 2, the reference to that classification, which is a 2018 document. So operative at the time that this finance decision was taken.
Would Mr. Donoghue's forward on page 388, in fossil fuel subsectors that we have classified as misaligned with the Paris Agreement, which subsectors had CDC classified as misaligned with the Paris Agreement?
On page 394, bottom left-hand corner, you see standalone upstream gas exploration and production. That is classified as misaligned by the World Resources Institute, the document of which is set out in footnote 2 on page 420.
I think you showed us this yesterday.
Yes, I did.
Yeah.
You did, but it fits into your current argument, because you say it's not just me saying that this project is inconsistent with the Paris Agreement on its terms. The British government has said the same immediately afterwards.
Yes, on the basis of information that existed in 2018.
Sorry?
On the basis of information as to alignment that was produced in 2018.
Right. That's the footnote.
Yes.
I just can't see the letter 2.
It's in the guidance document, which is in, it's a bit tricky because footnote 1,
I mean, I know it's page 420, but if I was looking at 420, it may be my eyesight, but looking at page 420, I can't see where the footnote little 2 is that takes you back to the 2018 reference.
so
It
it may be
I've got
your
it.
computer.
No, I've got it.
Yes,
Which can
so-
be consistent in certain circumstances.
Yeah.
2. It identifies 3 broad categories for infrastructure in relation to Paris Agreement misaligned, such as coal power, and conditionally aligned, which can be consistent in certain circumstances and be towards Paris alignment. So what's that document?
So that's the WRI document towards Paris alignment, which is at footnote 2 here, but is the same document that is referred to on the 1st of July when classifying gas as misaligned with Paris. And the reason, of
And where
course,
do we find that WRI document, and who is WRI?
we can send that document to you.
Sorry?
We can send it to you. We can send it to you. And this all fits in with the UNEP emissions gap report and production gap reports, which are produced annually. So you'll recall, my lords, first of all, SR 1.5,
Well, it needs dates and references. Yeah. Well, my Lord's just suggesting that this chronology, which does have some fairly critical references in it, should have page numbers and
some of these dates aren't in the chronology. The chronology is a helpful document, but what it does is to mix the substantive history of the case together with the procedural history, which is not unhelpful, but what we really want is the substantive history. And the documents you're showing us now and their dates and their cross-references in the bundles would assist us, I'm quite sure, if we could have a slightly more populated chronology.
We'll do that by reference to the pages. In retrospect, I wish we had just had the bundle below here, because all the documents refer to it, and we had a chronology with all the references, even larger than this one.
Well,
we'll do a job again.
I was looking to save you work by trawling through the judgment in the court below, but that doesn't quite do this for us.
Well, we'll do that for you. We'll try and compress it.
Thank you. Sorry to interrupt.
So just to tie that all up, this of course ties in with SR 1.5 in 2018, the document I took you to yesterday, what was actually going on and the implications of what was going on, and the annual production and emission gap reports, which of course would have been there in 2017 and 2018, and I took you to the 2019 versions, the UNEP emission and production gap reports. So by that time, it was clear that the further exploration and opening up of fossil fuel reserves was misaligned with the low emissions pathway in Paris. And now we need to go back to the Paris Agreement. Just to go back to Article 3, you'll see that the ambitious efforts that parties must undertake are defined in Articles 4, 7, 9, 10 and 11. And then you'll recall that in Article 4.1, that applies to all parties, but developing parties may peak later in terms of their national emissions. So not in terms of revenue from fossil reserves that they have in their territory, but they may peak later in terms of their national emissions. They must still nonetheless achieve net zero by the second half of the century. So there is a feasible pathway whereby, for example, developed countries achieve net negative emissions by 2050, as my Lord the Master of the Rolls was saying. So the developed countries achieve net negative, but the developing countries are still above the zero line and still emitting. They peak later, and they may indeed arrive at net zero later. So 2070 was, for example, originally China's commitment.
Can I ask? I'm sorry to interrupt, because I'm thinking about what you said 2 minutes ago. But what is troubling me is the UK government seems to have been proceeding along different lines. So we have the CCC.
CDC.
No, the CCC, the Climate Change Report.
Oh, Climate Change Report.
Which says on the one hand and on the other hand in 2020. And we have the ministerial submissions, which says on the one hand and on the other hand there is an argument. And that's swiftly followed by apparently government policy being, clear government view, being that this kind of thing, indeed, perhaps this thing, as two ministers thought anyway at the time, is contrary to Paris. Now, what I can't see is how the two whether there's any connection between, whether one hand was talking to the other hand, or whether, you know, in 2020, when the CCC was produced and ministers were being, whether they had the 2018 report, which later becomes government policy, which we haven't got in the bundles, which says what's aligned and what's not aligned. Because there seems to be a total disconnect but in thinking. And maybe because people are not talking to one another, maybe because it's different people taking different views. But it would be important to make a connection if there were a connection. I mean, how did the change occur so quickly from this could be compliant to this is definitely not compliant?
My Lord, I'm as troubled as you are by this situation. I should perhaps remind the court that the Foreign Secretary, the Secretary of State for Bays, who was the president of COP26, representing the United Kingdom, and DFID, all objected to this finance decision. That has some relevance. I also asked myself the question last night as to where the United Kingdom would be were the court to conclude that the Paris Agreement entitles any developing country to license international companies to open up all their fossil fuel reserves to obtain revenue, when that is contrary to their stated and public policy. So I am equally troubled.
It's unlikely that the court will decide that. More likely that the court will decide that in favour of Sir James' submission, which is that it was a tenable view. Maybe wrong, but it was a tenable view.
But the implications globally are rather similar and are contrary to the United Kingdom's stated position.
Yeah, but what I'm interested in is one of your strongest arguments, if I may say so, Ms. Seymour, seems to me anyway, I'm speaking only for myself, is that you say this is a breach of the Paris Agreement, and so does the UK government.
Yes.
Right? If that, you know, I'm just a judge, but to me that does have some apparent weight. But obviously the UK government didn't speak with one voice. And what I'm asking is, do we have any indication as to how the change occurred from, I understand some ministers always thought it was a breach of the Paris Agreement, but do we have any indication as to how the settled view emerged so that one side prevailed over the other, and when?
No, my lord, we have no information in relation to that. Usually...
Was it on the basis of legal advice?
I have no idea. There is no witness evidence in front of the court in relation to that. Usually, having represented the government on the panel, in this kind of case, one would have cross-departmental agreement in relation to this kind of case. I don't even know whether there is cross-departmental agreement as to the arguments that are being made in front of this court. We have no witness statements from any ministers, so I cannot help you at all. I'm afraid you're going to have to ask the respondents about that.
You just say, well, this is all very strange.
Well, worse than strange. My submission would be that it's not an acceptable position for the government to be split as to what it says to the world and what it says to the Court of Appeal.
Well, is that fair? I mean, I don't think Sir James is denying what the government is now saying to the world. I think Sir James is focused, I expect, on justifying the decision made on the 30th of June 2020 and nothing more. And he says, as a matter of law, that decision is defensible because of the principle of tenability.
And would be defensible today, in that if today...
Well, I don't think he does say that. I don't think he needs to say that if he were to get home on the first argument. But you say, well, it just doesn't stack up because the government has taken a clear view that is inconsistent with your submission, and the timing difference doesn't make a difference.
My lord, he would have to be able to say that for his argument even to be tenable.
He'd have to be...
Because he would have to be able to argue that the Paris Agreement does not have any hinder or prevent in any way developed countries financing companies like Total to open up fossil fuel reserves in developing countries for whatever reason, if the developed country could say that that would have economic benefit for
I mean, the
it.
difficulty...
That is his argument
I get
of
all
law.
that. But the difficulty is my Lord's question, my Lord Justice Bean's question, which is, are you really saying this could never be compatible with the treaty, with the agreement? And you are,
Yes.
and I know you've been very clear about that. If so, that's a big statement, because take China. I don't know anything about what China does in compliance with the Paris Agreement or not, but I would be surprised to hear that China had opened no more fossil fuel projects. Would I be wrong about that?
Again, there is a difference between, say, China discovered reserves of liquid natural gas and opened them up for use in China, and that fitted within their emissions commitments under their
overall personal,
they're national.
initials.
They're not selling globally, whatever. We're talking not about, even if the United Kingdom, we're not here on a case about whether the United Kingdom opening up North Sea gas. That's not our case here today. But that is not what we're here talking about. We're talking about the provision of finance to open up fossil fuel reserves for sale on the global market. That is what we're talking about.
I understand.
Yeah. But your challenge is based, in part at least, on the contention of irrationality in the decision that was made.
Yes.
So, in a sense, the differences of view which are manifest in the papers you showed us yesterday lie behind that decision. But the decision was what it was, and your contention is not that it was irrational because it was based on inconsistent ministerial positions. It was irrational because it was irrational. In other words, no reasonable government could have taken the view that it did ultimately take to commit itself to this funding. That, as I've understood the claim, is what you're perhaps principally contending.
Well,
and that is based on an interpretation of the Paris Agreement, which is, if you like, the touchstone for your contention that what was done was simply irrational in the good old-fashioned, dare I say it, Wednesbury sense.
well, it's the first sentence of Lord Green in Wednesbury.
Well, you said that yesterday.
Where he says a misdirection as to law is an irrational decision.
Yes, that's what you said to us yesterday.
Yes.
So is my formulation right or wrong?
Yes, I prefer to use based on an error of law, because now there is a sort of distinction that's drawn in
Yeah.
our understanding between irrational and an error of law.
Of course.
So our first point is that in determining, as I showed you by reference to the pleadings, in determining that this was consistent with a global low emissions pathway, the decision was taken, and therefore in alignment with the United Kingdom's obligations under the Paris Agreement, this decision was based on an error of law. That was wrong in law.
And you support that submission by saying, and you agreed with me 2 minutes after you'd made this decision. You, the government.
Yes, well, the current position is that it would be not be in alignment with Paris.
Well,
So-
that's the 1st of July 2020 position to which my Lord, I think, is referring. But the very day, if you will, after the decision was promulgated, something quite different appeared to be said, you say.
Yeah.
And then the documents you've been showing us just now reinforce, you say, that contention of a volte-face.
Yes, and the government now says that to provide for the opening up of fossil fuel reserves for the purposes of global sale, I took you to the March policy, is not in alignment with the Paris Agreement. It was no more in alignment with the Paris Agreement in June 2020. And so I say that Sir James Eadie is going to have to submit that this decision would be lawful today, putting aside the policy, putting aside arguments of you need to comply with your policy. So putting that aside, and assuming you can't get home on saying not in line with your policy, it would be lawful to do this today.
Thank you.
So as I've said, Article 4.1 allows developing countries to peak later nationally. So they can use fossil fuels later and longer than the developing countries, who will overcompensate for that through negative emissions potentially.
You say they can't sell them.
You can't sell them.
Where does the Paris Agreement say that?
That's the implication behind it. So there's nothing, there is no, what they're entitled to do is peak later in terms of emissions. But they are not entitled to they must make finance flows consistent with a pathway to low greenhouse gas emissions. So they can't sell in order to bring revenue. And that is accepted again by the government, in that the government makes it clear in its policy, in the footnote, it says no finance will be provided where the fossil fuels are for sale on the global market. You'll see that in the March policy. And then 4.3.
I don't quite understand, completely understand why Sir James, on your submission, has to say that the decision would be lawful today.
Because as I understand it, the argument that is being put to support the finding that this finance was compatible with the UK's obligations under 2.1c, the low emissions pathway, is that it is compatible with Paris for developed countries.
It's a tenable view that it's compatible with
Yes.
Paris.
It's I assume he's arguing that it's right, but right or tenable. Developed countries can finance or finance international companies to develop fossil fuels in developing countries to produce revenue for those countries if those countries say they need it. And that is his argument as to why there was no error of law, because he says that is permissible under the Paris Agreement. And it's as permissible today, I would submit, on his argument, as it would have been on the 30th of June.
But why does the fact that the government view has changed mean that his argument is unsustainable? It's a good jury point, if I may say so, but it doesn't prove that the view was untenable on the 30th of June.
No, that is of course correct. The government only has a view of the law, and it is ultimately your lordship's view of the law that is the law.
Well, I'm more concerned with the point that is what the government is arguing before us. It is unattractive for the government to argue before us that it was tenable on the 30th of June, that X was in compliance with the Paris Agreement, and a clear view on the 1st of July of the same person, notionally, an unnatural person, that it was not in accordance with the Paris Agreement. That is, as you say, an inconsistent argument, which is why you say they must be saying it would be a perfectly reasonable decision to take now. But either way, that's very unattractive. You're right that we have to take a view of the law ultimately, if we actually get to deciding it in the way you suggest we should. But the way the government puts its case, I mean, you started today by showing us the very clear view that they actually weren't just saying it was a tenable view. Their case before us was that it was compliant with Paris. So the contrast is even starker than the one I'm putting to you as between a tenable view and the new view. I mean, I suppose we have to make sense of all this, but I for my part, and it may be not maybe any my view, can see some force in the argument that it matters what the government says the law is.
Well, two points on that. First of all, Professor Douglas, yesterday, in arguing about tenability, drew your attention to the potential difficulties that might arise, one of which was that different departments might take different tenable views, which is an unattractive position from the perspective of rules. And international law provides for rules, albeit rules that apply globally. So, yes, my lord, that is absolutely right. My second response on that would be that crucially what matters is what ministers were told. And ministers were told, as I showed you in the pleadings, that this decision to finance was compatible with the United Kingdom's obligations under Paris, both under the low emissions pathway and in relation to assistance for developing countries. And that came from the pleadings, the point you just made. So, yes, it's unattractive, but of course, the government's position on the law, one or other may be correct, neither may be correct, and that is why it's important that the judiciary ultimately rules on these questions. And then 4.4, you'll see that developed countries have a responsibility to take the lead. So this is the common but differentiated responsibilities that is still maintained. Undertaking economy-wide absolute emissions. So this is the compensation point that my lord pointed out, reduction targets. So they must absolutely start reducing in absolute terms. That's in their own national efforts. Developed countries should continue enhancing, so increase their mitigation efforts. Don't start increasing emissions, they must increase their mitigation efforts, and they're encouraged to move over time towards economy-wide emission reduction or limitation targets in the light of different national circumstances. So a recognition, but certainly developed countries have to take absolute reductions and ultimately, in some pathways, need to lead into negative emission positions. And then if we go to 4.5, support shall be provided to developing country parties for the implementation of this article in accordance with Articles 9, 10 and 11. So that's support, financial and technological support, recognising that enhanced support for developing country parties will allow for higher ambition in their actions. And if, my lords, go to Mozambique's NDC, we don't need to, but you may in your reading go to them, you'll see that in fact Mozambique's INDC at that time, so it's pre-Paris, actually says that it's conditional on financial support for moving to renewables, etc. And then if we go to 4.19, all parties should strive to formulate and communicate long-term low greenhouse gas emission development strategies, mindful of Article 2, taking into account again their common but differentiated responsibilities and respective capabilities in the light of national circumstances. And then Article 9.1, which is referred to in Article 3, developed country parties shall provide financial resources to assist developing country parties with respect to both mitigation and adaptation in continuation of their existing obligations under the Convention. And other parties are encouraged to provide support. And then 3, as part of the global effort, developed country parties should continue to take the lead in mobilizing climate finance from a wide variety of sources, instruments and channels, noting the significant role of public funds through a variety of actions, including supporting country-driven strategies and taking into account the needs and priorities of developing country parties. Such mobilization of climate finance should represent a progression beyond previous efforts. Now that's specific climate finance. 21C covers something much wider. It covers all finance. And then 9.5, developed country parties shall biannually communicate indicative, quantitative and qualitative information related to paragraphs 1 and 3 of this article as applicable, including as available projected levels of public financial resources to be provided to the developing country parties. Other parties providing resources are encouraged to communicate biannually such information on a voluntary basis. And we have in the bundles the communication by the United Kingdom as to what it has done, where it explains the emissions that it has enabled in developing country parties by reference to finance that it has provided. And as I said earlier, what it does not do there is record the emissions that it has played a part in creating through finance that undercuts those efforts. And we'll give you the reference to that document. And then 9.7, developed country parties shall provide transparent and consistent information on support for developing country parties provided and mobilized through public interventions biannually in accordance with the modalities, procedures and guidelines to be adopted by the conference and parties. I'll give it to you. And then Article 11, we have capacity building. Enhance the capacity building of developing countries, in particular countries with the least capacity, such as the least developed countries, that would be Mozambique, and those that are particularly vulnerable, that's Mozambique. Such small island developing states to take effective climate action, including to implement adaptation and mitigation actions, and should facilitate technology development, dissemination and deployment, access to climate finance, relevant aspects of education, training and public awareness, and the transparent, timely and accurate communication of information. And then 9.4, my lords could also read, 11.4. So the UK communication is tab 55 for your note, and you'll see there that the UK explains the gigatons of emissions that it has assisted developing countries to reduce, but not the ones that it has caused to increase. And finally, Article 20, it is clear that this is a binding treaty, and you see that in Article 22, by reference to regional or economic organisations that can also sign this treaty, such as the EU. Party to this agreement, without any member state being party, shall be bound by all the obligations under this agreement. So if a regional body signs up to it, that regional body is also bound by all the obligations. So that, my lord, is the Paris Agreement, and I'm now going to get on to ground 3. We've done a lot of it, actually, in over yesterday and today. But I want to deal with respondents' case on ground 3, error of law. The respondent has said in paragraph 1 of their skeleton that this project will have a significant climate change impact by increasing global emissions. And I refer you also to paragraphs 2.3 and 37. As I've said, increases in emissions have a direct linear relationship with increases in temperature rises, and I took you to the IPCC for that. I'm not going to repeat the numbers. You'll recall that emissions need to be falling globally by 6% per annum from now, and I took you to the emissions and production gap report. Accordingly, the respondents accept that this project will produce emissions over 30 years that will lead to an aggregate increase in global emissions, is, we say, an explicit acceptance that this project is not in alignment with the temperature goal in Article 2.1a and indeed undermines it. And it's worth perhaps taking you to a note which reveals the thinking behind this. If we go to the supplementary bundle, tab 45, now, this was the last-minute flurry on the 30th of June, when the Prime Minister had said that although he was willing to allow the project to go forward, he wanted to know how much it would cost for the United Kingdom to install carbon capture and storage to compensate somehow for the emissions for which the UK would be responsible through its finance. And in order to do that, it was necessary to work out the Scope 3 emissions, which previously UKEF had said was not possible. And you'll see that on the back of an envelope, through very simple physics, a simple calculation, a rough estimate of emissions was drawn up quickly to get to the Prime Minister. And you'll see it says, sorry, there are a number of emails flying around. Overall production figure, 12.88 megatons per annum. That's the Scope 1 and 2.
Sorry, did you give us a page number?
Sorry, page 355.
I was nearly there. It's on the wrong page. Thank you very much.
So you see 12.88 megatons per annum. That's just Scope 1 and 2. That's not from the liquid natural gas. That's from the actual production facility. And then you get overall emissions on Scope 3. That's just the liquid natural gas production multiplied by a factor to get the emissions. And you see 805.75. If you add to that the 12.88 multiplied by 25, you get a sum in around 1.12 gigatons over the period. So he explains that the carbon emissions is calculated using a carbon content for the product and 1 tonne of oil equivalent, and it uses a method called Jukes. And there's nothing wrong with the Jukes method. Then converting the megatons into tonne, you get the emissions. And then he says, however, it should be noted that this is a very simplified approach, and it should only be considered a very rough estimate of the potential Scope 3 emissions. For instance, it's likely only to be carbon dioxide emissions and not include other emissions. And you'll find in Mr. Muttett's statement an explanation that methane, and you'll know from the news, methane is a much more potent emission and is not calculated here. So he says, so it's not CO2 equivalent, which is what one would normally calculate for the purposes of the budget. It also will not include Scope 3 emissions associated with transporting the LNG and the processing that it needs, so the emissions from processing.
Well, we've read that email, yeah.
So very rough intel only. But why I'm taking you here is the final paragraph. And I'm just taking you here to show you the thinking that is behind this decision. But ultimately, it should be noted that LNG investments and supply will continue to grow until demand is abated. As such, Scope 3 emissions will either come from this project or another way. So what really is happening here is that there is not a focus on the low emissions pathway, there is a view that if we don't do it, somebody else is going to. So if we don't open up, if this resource is not opened up, someone else will open up another resource. And what the reason I take, my lords, to this document is because of the reference to until demand is abated, we will just carry on opening these fossil fuel reserves up. Now, Paris does not address demand. The parties did not decide to address this problem by reference to demand. They could have done. Feasibly, one could have had a treaty that stated all transport must be electric based on renewables by X date. It is prohibited to open up or use fossil fuels. It did not choose to do that. And this focus on demand ignores what Paris was saying, was that reduction is what needs to be done. Reduction in production, reduction in use, reduction in emissions. And all parties must undertake ambitious efforts, as set out in Article 3.1, to reduce emissions. Now, this is the criticism that UNEP itself set out in the emissions gap report. It said that governments are continuing to open up, or companies are continuing to open up supply to meet demand, and that is not in alignment with Paris. Now, we say the numbers speak for themselves. The project will lead to an increase in global emissions where there's no capacity for further emissions nor for further production, and where there's no suggestion that other projects will be mothballed or closed to compensate for this one, something that Total, the interested party, accepts is necessary in order to stay within the pathway. And if I can take you to that, that's at Core Bundle, tab 9. Paragraph 42, which is at page 107. Total says, further, as noted above, there is no single pathway to the temperature goals. The IPCC SR 1.5 envisages a large number of scenarios. And then there is scope to accommodate the LNG from the project in these 1.5 compliant scenarios. However, the question is whether it should be from LNG from Mozambique or from existing LNG producers in developed countries, and whether bodies such as UKEF should support one, other, or the both, is one that can't be answered by scientists or this court. Well, we respectfully disagree. The point it is making there is that yes, you can open Mozambique, and the question really is whether it comes from Mozambique or from existing production. Well, there is no proposal to close existing production, let alone to close more production than proposed from this project. If Total was saying, we are going to open up this project with, I believe, 25 trillion barrels equivalent, but we are closing our project in Papua New Guinea, for example, which is opening up 60, and therefore we are making a 25 net reduction, that would be one thing. They accept that opening this up and maintaining existing projects is not within the 1.5 degree pathway. Now, the financing is not, in our submission, in alignment, and Lord Justice Stuart-Smith accepted or stated that he was willing to accept, albeit not find, that a finance flow that increases aggregate global emissions is not consistent with a pathway to low emissions, greenhouse emissions. And he says that at paragraph 228 of his judgment. And the reason that it can't be compatible with the UK's obligations with under the Paris Agreement are as follows. First, Article 3, the obligation to undertake ambitious efforts to achieve the objectives in Article 2, the temperature goal, and the obligation to make finance flows align with the low emissions pathway. 2, the link in 2.1a to Article 4 to create that pathway. 3, the pathway as set out now in IPCC 1.5. 4, the specific statement in 2.1c, and further the obligations under Article 9.5 and 4.5 to help developing countries increase their emissions.
Sorry, the articles you gave us there were 2.1c.
And then 9.5 and 4.5. So turning then to the respondents' submissions, I'm going to take them as quickly as I can. The reasoning they say for saying that this is all in alignment with Paris, in paragraph 1 of their skeleton, is fourfold. First, they say that there's no explicit prohibition in Article 2.1c. They say it's only declarative of an aim, and that's in paragraphs 2.2 and 41 and 45 of their skeleton. They also say, to quote, had the parties intended to prohibit financial support for fossil fuels, which might, notably in the short term, increase GHG emissions, they would have said that. And I note short term, because of course we know nothing about the analysis in terms of time, say the 25-year period, which in climate change terms is not short term. And indeed the project is in fact 30 years, and you find that in paragraph 45.4. So as to that, we say 2.1c is core to the central objectives. It's connected to the temperature goal in 2.1a and 4.1, and the states are committed as parties to take the ambitious efforts to achieve it as provided for in Article 3 and 4.5. Put simply, parties are committed and obliged to undertake ambitious efforts to achieve that aim, and it is plain that doing something which is contrary and undermines an aim cannot be undertaking ambitious efforts to achieve it. We say something that is contrary to an objective or an aim is not compatible with it. Accordingly, we say that the financing of this project is not compatible with, in accordance with, or in alignment with the UK's commitments under the Paris Agreement. Secondly, the respondents say that Article 2.1c imposes no substantive obligation to do anything. They say that the only substantive obligation in the Paris Agreement, to quote, is to pursue domestic mitigation measures with the aim of achieving the objectives of such nationally determined contributions. And you find that in paragraph 42.2 of their skeleton. In effect, my lords, they say it is up to states what they put in their nationally determined contributions, in their language at paragraph 4.4, what they have judged appropriate. That's a quote from their skeleton. The only obligation, they say, is to do what they have judged is appropriate. And it's worth perhaps going to 42.4 and 44 of their skeleton, which is at tab 8. 44 especially, achieving whatever they have judged appropriate and set out in their NDCs. So in a sense, all they have to do is say something in the NDC, and that's all they have to do, and they can do anything outside of the NDC that completely undermines that effort. Now, as to that, we say this ignores the crucial obligation that states are obliged to undertake and communicate, including by NDCs, in order to achieve the goals in Article 2. And you find that in the key article that the respondents entirely ignore in their submissions, Article 3, which I took you to. Article 3 obliges states to undertake and communicate ambitious efforts, including as set out in Article 4, with a view to achieving the purpose of the agreement as set out in Article 2. The NDC obligation in Article 4 is mandated by Article 3, which ties its nature and scope to the aims in Article 2. The NDC does not limit your efforts or your obligations under the Convention, let alone enable you to undermine them. On the respondent's argument, in order to be obliged to do what is set out in Article 3.1, you would have to write in to your NDC Article 3.1 and Article 2A to C. So they deny the connection between those provisions. But indeed, the obligation in relation to NDCs is not merely to set out commitments in an NDC, which they say is entirely a matter for them. It is to undertake ambitious efforts.
I mean, is this, some of this not really reply submissions? You know, we know what you say it means, and we know from the respondents' skeleton what they say it means. I mean, coming back and saying what they say is wrong because what I say is right is really the stuff of reply, isn't it?
Well, I always assumed that I had to deal with their arguments, but they're before, and then I only reply in relation to new points. But that's court practice. I had intended to deal with their points.
Well, bearing in mind we're limited for time.
Yeah, well, I'm going to be all right, I think, if we can push slightly to after lunch. If I can push into half an hour or so after lunch, then I think we're going to be okay, because I've covered a fair amount of ground.
Okay.
And Mrs. Justice Thornton deals with the Tameside argument in great detail, and no facts have been put in dispute as to what she set out there.
Right.
So we say so at 45.2 of their skeleton, if you've still got it open, they say, still ignoring 3 and 4.1, yes, the NDC must recognise the goals in Article 2, but that doesn't mean that 2.1c generates any obligation. That's the use of their language. But we say this is to miss the point. The point is not whether Article 2.1c generates a freestanding obligation. The question for this court is whether it is compatible with the state's commitments under the Paris Agreement for it to do something that undermines the achievement of the temperature goals, in this case through finance flows that are not, on the respondent's own case, consistent with a low emissions pathway. That is a pathway in line with the objectives temperature goals. And I should note, perhaps, that was in the statement of Maxwell Griffin, Mr. Griffin for the respondents. He says that there is absolutely no threshold for support for in relation to emissions for financial support. So UKEF can give financial support, or could have given financial support, irrespective of the size of the emissions. So irrespective of the degree by which they were outside of the pathway. And you find that in Supplementary Bundle, tab 4, page 3, paragraph 111 of his statement. Thirdly, at 45.3, and I hope my Lord will forgive me for dealing with these because they are important points. We say that seeing the weakness in their own argument, they resort to what is the desperate language of the Vienna Convention should not be taken too far.
So 45.4 that is, I think.
45.4.
Yeah.
And they say that had the treaty imposed a prohibition again, it would have said so. Now, we don't understand what it means to say that one shouldn't take the Vienna Convention too far. The Vienna Convention is a set of principles for interpreting treaties which reflects customary international law, and it's for the court to apply those principles properly. The heart of the strengthened response to climate change that the Paris Agreement represented is the recognition that to prevent dangerous climate change, which remains the overall objective of the UNFCCC, more action needed to be taken by reference to the specific temperature goal, urgent accelerated mitigation, more effective adaptation, and consistent finance flows. Whatever the difficulties of the negotiations, the outcome centred on this, and the need for effective measures based on science, which address equity and the eradication of poverty. Fourthly, the respondents say that even if not correct, it was nonetheless tenable for them to have considered that despite the project causing emissions increases that would prevent the temperature goal from being met, it was nonetheless compatible with the aims of the Paris Agreement because those aims are, to quote, in tension with one another. And you find that at 39.2. And they rely on a claim in paragraph 1 of the skeleton, their skeleton, that the project, they say, has the potential to lift millions of Mozambicans out of poverty. At paragraph 52, they explain why they say fossil fuel reserves in developing countries can still be exploited compatibly with the Paris Agreement, even if it means the core objective of the agreement will be frustrated, provided it brings economic benefits to those countries that could pave the way for a low carbon transition. They use thereby, but it is important to be clear that in this case there is no clear plan in that regard. And indeed their internal advisor, Mr. Caldecott, noted that there was no plan produced by Mozambique for these revenues to be used specifically, outlining how this would be used to create a renewable-based economy. But in support of their argument, they make 3 points. At 52.1, they rely on the fact that emissions in developing countries can peak later. At 52.2, they rely on the fact that pathways include possibilities of emissions getting worse before they get better. And last, they make the claim that climate-resilient development can trump the temperature goals, and that here Mozambique is supportive of the project because it believes revenue will assist it to become climate resilient. I'm going to take those points together. As regards the reference to pathways in 52.2 and 52.3, I've already said the global pathways are set out in SR 1.5. I took you to those. And obviously the temperature goal cannot be achieved by a single state within that pathway, increasing its obviously the temperature goal can be achieved, as my Lord said, if there is a compensation between states. And as I also said, Article 6 provides a mechanism for that. But that does not in any sense lessen the duty to move as quickly as possible to reductions. And that is not, moreover, what we are talking about in this case. again, as I've said, only 5% of this gas is to be used for Mozambique. And I referred you to the World Resources Institute, and I took you to those footnotes. I'm not going to do that again. But projects such as this are misaligned as they were in 2018. And the reason they are misaligned is the science. The fact that revenues might be used to purchase renewables cannot negate the global impact of the emissions. That is not peaking later for the purposes of Article 4.1 for the developed country. As to the point that emissions can get worse before they can get better under certain pathways, again, I've taken you to the pathways. It's plain that we are talking about two different things, global emissions and national emissions. And I also explained to you the risks in relation to CCF and negative emissions technology. And we submit that it is surprising that the UK government should be advocating increasing global emissions at this stage in direct contradiction to its stated public position. We say the argument that it is permissible for developed countries to facilitate the opening up of fossil fuel reserves in developing countries in order to provide revenue to those developing countries is a complete misunderstanding of the entire structure and purpose of the Paris Agreement. And it derives, my lords, from the erroneous view of Lord Justice Stuart-Smith that climate resilient development and preventing climate change are in conflict with one another, and as such 2.1c is internally contradictory and doesn't make sense. And his view that the Paris Agreement Standing Committee on Finance, and that's an important paragraph, it's in paragraph 25 of his judgment, he didn't understand how the Paris Agreement Standing Committee could say, look, it's not that all finance needs to cause a reduction in emissions, it's just that no finance should make emissions worse. And that's fairly plain what they meant, because that's a direct interpretation of 2.1c. You'll find it in his judgment at paragraph 25. Perhaps it is worth going to his judgment. It's in the core. Core bundle 11, paragraphs 2 to, let's start at 2 at 25.
Recital 6.
Oh, I'm afraid I've got the wrong reference. Maybe it's, I'm 225, maybe it was a typo. Maybe let's go to 225, let's hope to find it there.
That's the first paragraph under the heading the Paris Agreement.
You probably were thinking of 225.
This is where he
29.
summarises the
Apparently
main
it's in 29.
provisions in dispute.
I must have just mistyped the number. Apparently it's 29.
29.
29 or 229?
29, I'm afraid. So here we have the Standing Committee on Finance, and he set it out. You have it in the bundle, but here it is written. This is a Paris Agreement body. Although climate finance must obviously be scaled up, it's also important to ensure the consistency of financial flows as a whole. So that was what I was talking about, investment, insurance, guarantees, etc. Pursuant to Article 2.1c of the Paris Agreement. This does not mean that all finance flows have to achieve explicitly beneficial climate outcomes, but that they must reduce the likelihood of negative outcomes. Although commitments are being made to ensure that finance flows from development financial institutes are climate consistent, more can be done to understand public finance flows and ensure that they are all consistent with countries' climate change and sustainable development objectives. So they mustn't have negative outcomes. And that is because the obligation in 2.1c extends to requiring states to make all climate flows, including private finance flows. And the UK has done a very good job of that in relation to reorientating the City of London. And then 227 to 228, he says he doesn't understand what this means. He says, I am not alone above, and the SCF's statement that Article 2.1c does not mean that all finance flows have to achieve explicitly beneficial climate outcomes, but that they must reduce the likelihood of negative outcomes. Quite how what is meant to be applied to a case such as the present, where Mozambique's ability to make its way to a carbon-free economy and climate-resilient development is, by the way, that is incorrect, because there is no evidence that it is dependent upon the income stream from this project, is unclear. And then 228. And then 231. Perhaps my notes could. He says in the middle, once the Paris Agreement is approached on the basis that it does not give rise to hard-edged freestanding obligations, but should be seen as a composite package of aims and aspirations that may be, and in this case are, in tension or frankly irreconcilable, UKEF's approach, which involved recognition of those conflicting aims and aspirations and an evaluative balancing exercise in order to come to conclusion, cannot be criticised.
Will you say that's not the UK's approach?
No, the UK found, and the ministers understood, that this was consistent with a low emissions pathway. And that's why, scattered through the evidence and the materials, I would submit, language of net reduction is persistently used. And nowhere in any of the documents do you ever see the word increase, let alone aggregate increase. And indeed, in Mr. Griffin's statement, you find the language of net global reduction in emissions by this project.
So I'm sorry if I'm taking you back to something you told us very clearly and firmly yesterday. Where is the best reference or references to the ministers having found that this was actively compatible with a low emissions pathway?
This is the material that I took you to in pleadings in the beginning. So all you have I took you to everything that the ministers, we know documentary. Of course, we don't have minutes of meetings.
No.
We don't actually. Also, we don't know what's under the redactions. So we don't know exactly what happened in chats and etc.
No, but the evidence before the court.
The evidence before this court, we say, is in the pleadings, in all the references I took you to this morning, and in paragraph 1 of the skeleton. But we can give you all the references to the detailed grounds of defence.
Yeah, but I think you're misunderstanding. My lord is asking you where the ministers decided that this was compatible with the Paris Agreement. But the answer is the ministers didn't really decide that. The ministers were told.
That's the point.
It might be.
No, they were told it was. That's the evidence. The evidence is.
I see. So you mean that's the evidence of Mr. Louis Taylor? He says we decided it was.
Exactly.
But actually, the ministers get told something different, which is that it's a balance.
No, my lord, we don't know. All we know is what is in the documents in front of us in terms of written submission.
Yeah, but I mean, CCC, we went through it this morning. CCC, and we've got the references, says on the one hand and on the other. Right? It says there's an argument, but the argument is that this will reduce emissions because less dirty kinds of fuel will be used. The ministers say there's a legal risk of challenge, which implies that they may be right and they may be wrong on that argument. And the evidence is that Mr. Taylor thought it was compatible, right? Said it was compatible. The government's argument is that it was compatible. Full stop. That was the decision that was taken. That's what we're told, right? So that's all we've got. We haven't got anything else.
You cannot proceed on that basis. You cannot proceed on the basis that, oh, the ministers didn't know that.
Didn't know what?
Didn't know that the position, as stated in the pleadings, that it was compatible with the low emissions pathway and assisting development in Mozambique. Ministers didn't know that. You have to proceed on the basis that this decision was taken on that basis, that ministers took it on that basis. Otherwise...
Yeah, but my lord is asking you, where is that to be found? And the answer is only in what you showed us this morning.
Yes.
Right. Fine.
Yes.
So we have to, it may be the correct legal approach. We have to infer from the contemporaneous materials that the advice given or the statements made by officials and others, absent any contradiction of that in contemporaneous or subsequent material, evince the decision-making conclusions of the ministers and ultimately Mr. Taylor.
Absolutely. Unless you had a witness statement in front of you saying, look, we thought it was compatible with the low emissions pathway and the duty to developing countries. But by the way, the ministers who took this decision didn't actually know that we thought that, and they adopted the decision on the basis that they were quite content to go ahead whether or not it was compatible with Paris. If you had a witness statement to that effect, therefore it doesn't matter whether it's compatible with Paris or not. But as it is, as happened below, as was contended below, as is contended in front of this court, this decision was taken on the basis of a determination that the finance provision was compatible with the United Kingdom's obligations under the Paris Agreement, both in relation to the low emissions pathway and in relation to assisting developing countries. And I cannot see how my lords could proceed to say, well, they may say that, but actually, when we look at the documents, we don't think really the minister thought that.
Oh, no, I wasn't suggesting that. What I was actually getting to was, or trying to get to, was where it's definitively stated specifically that this decision would be compatible with the low emissions pathway predicated in the Paris Agreement.
Well, it may be under the redacted bit. We did ask for the legal advice that was given to ministers. This is legal advice, essentially. Is it compatible with the Paris Agreement? It may be under a redaction.
Or separate privileged legal advice.
Separately privileged legal advice, which we asked for and we were refused. At no point has it been said, and Mrs. Justice Thornton makes this point, that even if the ministers had known it was not compatible, they would nonetheless have taken this decision.
No.
So the idea, just coming to this development point, which I want to deal with before we rise, because it's obviously an extremely important point in light of the way Lord Justice Stuart-Smith decided the case.
So which point is important?
This is the point, and actually we need to look at 232 of his judgment as well, because he says at 232, towards the middle, just below the middle, allowing for the sake of argument and without deciding that the project's emissions and their funding, viewed in isolation, tend to offend against the principle in Article 2.1c, that cannot be the end of the inquiry, since relief of poverty is a compelling counterweight in the argument. So he expressly says in that paragraph and the previous one that they are in conflict, and that poverty reduction can enable you or permit you not to finance flows that are not in line with the low emissions pathway. Now, we've dealt with that in detail in 37 to 41 of our supplementary skeleton, and my lords, I hope we'll go to that. I just want to make a couple of points. First, I've made the point that climate change above 1.5 degrees will be devastating for Mozambique, and there is no dispute about that. And I quoted in that regard from Alok Sharma, and he said at the end of that quote, whether it is adaptation or emissions reduction, we know that without finance, tackling climate change is well nigh impossible. And in fact, the seriousness of the impacts of this project are set out in the ESHR produced by UCARE, which refer to the fact that the project itself is being built to resist increasing cyclones, which will be caused by climate change. And that's a supplementary bundle, tab 34, page 271. And unfortunately, you don't have the whole of that report, which was in front of the court below, that also shows the devastating impacts of the project on Mozambique's population, with at least 4,000 people who rely on fishing losing their livelihoods, large displacements of population. And there is no positive assessment of the development benefits, certainly not one that takes account or assesses the relative consequences of the temperature goals being missed, increased drought, etc. Secondly, climate resilient development means sustainable development, and it's a core part of the Paris Agreement, and that's recognised by Mrs. Justice Thornton at paragraph 263. And the three of the four pathways I showed you in the SR 1.5 report are actually development pathways. And this can also be found in the Sustainable Development Goals, which we have provided in the authorities bundle 4.
So what does this point go to?
This goes to the key point now being argued by the respondents, found by Lord Justice Stuart-Smith, that you can counterweight. So you can provide finance that's not in alignment with the low emissions pathway if it's for development benefits, because there's an internal contradiction in 2.1c, he says. And we say that that's profoundly wrong.
Well, you can counterweight, but not in this way, you say.
You can't
Internally, you can counterweight.
Well, no, in the sense that you still have to meet you still have to align.
Yes, but if you had a massive project in London creating liquid natural gas, and you close down all your...
Yes, well then you'd be in alignment.
Yeah, that's right.
So you wouldn't need to counterweight.
You say you can't counterweight in this way.
Yeah, you can't be out of alignment because it's for development benefits. That's not permissible under 2.1c and would actually just blow a total hole through the Paris Agreement. So if we go to Authorities Bundle 4, tab 55, and I'm going to just give you some references to look at, please. I'm sorry to do this.
This is the
Sustainable Development Goals.
This is the 2030 agenda for sustainable development.
And this was September 2015. It preceded Paris, and it was part of a three-pronged set of measures to deal with poverty, climate change, and disaster relief. And I just want to sideline, you've seen the sideline on 3117, just in the beginning of the preamble, we're determined to take bold and transformative steps which are urgently needed to shift the world to a sustainable and resilient path. So the use of the same language. Just under planet, that's highlighted. Then the next page, you see under partnership, the interlinkages and integrated nature of sustainable development goals are crucial importance in assuring the purpose of the new agenda is realised. And then if we go to 3120, at the bottom of 3120, climate change is one of the greatest challenges of our time, and its adverse impacts undermine the ability of all countries to achieve sustainable development. Increase in global temperature, sea level rise, ocean acidification, and other climate change impacts are seriously affecting coastal areas and low-lying countries, including many of the least developed countries. The survival of many societies and of biological support systems.
I mean, what is the nub of the point in this document?
The nub,
because it seems to be a lot of the same statements.
okay, well, I'm going to take you to the specific reference. There's a lot sidelined in this document.
Yes.
This is directly tied with the climate change agreement. So if you look at page 3130, you'll see goal 13. Take urgent action to combat climate change. It's one of the sustainable development goals. And you'll see the footnote in the star acknowledging the UN framework for climate change is the primary mechanism. And everything else we have highlighted in this document, if my lords could go to it when they have time, if they ever have enough time. And of course, the UK is committed, but the crucial point for our purposes is they are linked, inherently linked. And finally, I'm just going to go to an OECD report that makes this more than plain at the next tab 57. And I'm going to give you some references, I'm afraid, and ask you to read that if you wouldn't mind when you have time. 3163, the first 3 paragraphs.
Just a second, if you would. Yeah.
And just to quote, first, actually, I am going to quote from this one, since we're in the preface. Paris Agreement development cooperation remains at risk of supporting development trajectories that are unsustainable, undermine effective action to address the climate crisis, and thus push urgent development goals out of reach. And then the severe impacts of climate change. And mutually, so that's the second paragraph, mutually reinforcing agendas, they are. It is becoming ever more evident that climate resilient development is not only a necessity for humankind, but also presents fresh opportunities. And then the next paragraph, it identifies what Paris alignment means for development cooperation and underscores the importance of ceasing decisions that tie countries to outdated, risky, high emissions activities and to insufficiently adapted development. And then in the forward on the next page, the second and the fourth paragraph, they are marked up. And then 3173, the whole of the executive summary. And then you'll see in the beginning of the first, you'll see the first paragraph ends with the sentence, sound climate policy is sound development policy. They are indivisible. And then it remarks about the slow progress towards meeting the Paris objectives. And then if we go to the following page, you'll see in the bottom bullet, large volumes of finance are available globally, but systemic barriers impede investment in low emissions, climate resilient infrastructure in developing countries. Providers should focus on effective partnering to promote finance for investments in low emissions and climate resilient infrastructure. And then 3177, again, that's marked up for my lords to read. 3178, 3179, and then on 3180, the third paragraph down, recognising that sound climate policy is sound development policy is the first vital first step. And then 3181, again it's all marked up to 3182, 3184.
Did you tell us the date of this document?
This is very recent.
Is it on the front cover?
2019.
2019, that's right. And then on 3184, the central concern of many providers to date has been to align financial flows with the objectives set out in 21C. This is especially the focus among multilaterals, which are primarily bank-like institutions that are more likely than non-bank providers of development cooperation to use debt financing to fund big-ticket projects such as infrastructure. While finance for low emissions, climate-resilient infrastructure is critical to achieve the objectives of the agreement, it's equally important to expand the scope of Paris alignment to include other social and economic sectors. And then 3185, 3187. And that's all marked up, 3189. At the bottom of 3189, lack of coherence in donor countries' broad international activities counteracts climate action through development cooperation. The Paris Agreement highlights the role of developed countries in supporting developing countries' mitigation, adaptation and resilience efforts, including through financial support and cooperation for